Okay, good afternoon. Thank you for being here today. This is our first family webinar for the 2024-2025 school year, and I hope the information that you gather is beneficial to your family. Today's topic is Know Your Rights, and this will be a brief overview of the Notice of Procedural Safeguards. My name is Sarah Untersey, and I am the School Family and Community Engagement Consultant here at the Region 10 Education Service Center. Joining me is Jim Wright with Partners Resource Network. Today's webinar is being recorded and will be available on the Region 10 website in approximately 7 to 10 business days. What is the Notice of Procedural Safeguards? So the Notice of Procedural Safeguards explains parents' rights and responsibilities under the Individuals with Disabilities Education Act, or IDEA. Today's presentation is going to be a brief overview of each section of the procedural safeguards. While this might not be the most exciting topic, it is very important. The full version of this document is available in over 24 languages on SPEDTex.org. Okay, let's start with when you should receive a copy of the procedural safeguards. So IDEA requires that school districts and charter schools provide the procedural safeguards to parents at least once a year and on the following occasions. So upon initial referral or request for evaluation, on the first occurrence of filing a due process hearing complaint or a special education complaint during the school year, if there is a disciplinary change of placement, and then anytime there's a request by a parent. There are language requirements for the procedural safeguards, and schools must provide a copy in the parent's native language or other mode of communication unless it is clearly not feasible to do so. SPEDTex has translated the procedural safeguards and the ARD guide into over 24 languages, and both documents are available on the SPEDTex website. So on page 1, we talk about foster parents. And a foster parent for a child with a disability may serve as the parent as long as they agree to participate in the special education decisions and complete the required training before the child's next ARD meeting, but not later than 90 days after they begin acting as the parent. For surrogate parents, if after reasonable efforts, the school cannot identify or find the parent of a child, or if the foster parent is unwilling or unable to serve as the parent, or if the child does not reside in a foster home setting, or if the child is a ward of the state or an unaccompanied homeless youth, then the school must appoint a surrogate parent to act in place of the child's parent, unless the child is a ward of the state and the court has already appointed a surrogate parent. Surrogate parents must complete the required training before the child's next ARD meeting and not later than 90 days after the initial appointment as a surrogate parent. On page 2, we start talking about child find. And child find means that all children that are living in the state that have disabilities and might need special education services need to be located, identified, and evaluated. And this includes children with disabilities who attend private schools or who are homeschooled. Prior written notice. The public school must provide you with certain written information, and this is called prior written notice. So prior written notice must be provided by the school before it proposes or refuses to start or change the identification, evaluation, educational placement, or special education services that are provided to a child. The school must also provide prior written notice, even if you agreed to the change or requested the change. And the school must give you that prior written notice at least 5 school days before it proposes or refuses the action unless you agree to a shorter time frame. Parental consent is covered on page 3. Informed consent means that you have been given all of the information related to what the school is asking permission to do. Consent must be voluntary. Granting of your consent is voluntary and it can be revoked at any time, but it must be done in writing, and revoking consent is not retroactive. Parental consent is required before conducting an initial evaluation for special education, to provide special education services for a child for the first time, to reevaluate a child, unless the school can demonstrate that it took reasonable measures to obtain your consent and you failed to respond. An independent education evaluation, or IEE. If you disagree with an evaluation that has been provided by your child's school, you have the right to request that your child be evaluated at the school district's expense by someone who does not work for the school, and this is called an IEE. When you ask for an IEE, the school must give you information about its evaluation criteria and where to get an IEE. From pages 5 to 8, we start talking about discipline procedures. So if your child violates the school's code of conduct, the school must follow certain procedures if it removes your child from their current placement and if that removal constitutes a change of placement. So for up to 10 school days, your child can be suspended during the school year, and that does not create a change of placement. For more than 10 days, if your child is suspended, then a change of placement has occurred, and an admission review, dismissal, or ARD meeting must be held to conduct what's called a manifestation determination review, or an MDR. The Manifestation Determination ARD Committee will review all of the relevant information and will determine if the misconduct is a manifestation of the child's disability, or if it's the result of the school not implementing the student's individualized education program. Is the misconduct, a manifestation of the child's disability? If yes, then the ARD committee is going to consider behavior intervention plan. And if no behavior intervention plan has been in place, then the school is going to conduct a functional behavior assessment, or an FBA, and implement that behavior intervention plan. If there is already a BIP in place, then the ARD committee is going to review and modify the BIP. If the MDR ARD committee determines that the misconduct is not a manifestation of the child's disability, then your child can be disciplined in the same manner and for the same duration as non-disabled children. Your child must continue to receive free appropriate public education. If your child's conduct was the direct result of the school's failure to implement the IEP, then the school must take immediate steps to remedy those deficiencies. Your child must be returned to the placement from which they were removed, unless the misconduct involves a weapon, illegal drugs, or serious bodily injury to another person. There are protections for children who have not yet been determined to be eligible for special education if the school had knowledge that the child had a disability before the behavior that resulted in disciplinary action. Okay, page 9, we move on to educational records. So upon your request to review your child's records, the school must make them available without unnecessary delay and before any ARD meeting, due process hearing, or resolution session, and no later than 45 calendar days after the date of the request. If you request copies of your child's records, the school can charge a fee for copying those, as long as it does not prevent you from being able to inspect and review the records. Your consent or the consent of the adult child must be obtained before any education records can be released to people or organizations outside of the Texas public school system. Parents have the right to voluntarily place their child in a private school, but federal regulations do not require a public school to pay for the cost of the education, including special education and related services, for a child with a disability at a private school or facility if the public school made free appropriate public education, or FAPE, available to the child. Transfer of parental rights, and this is on page 11. All parental rights under federal regulations transfer to a child when the child reaches the age of 18 in Texas. The age of 18, a child has the right to make all of their own educational decisions. The school must still provide parents with that notice of ARD meeting, and also the prior written notices, but that parents may not attend the ARD meeting unless the adult student specifically invites them to the meeting or the adult student gives them that right in a supported decision-making agreement. On or before the student's 17th birthday, the school must provide you written notice about that transfer of parental rights to your student, unless you have obtained guardianship or the student signs a valid power of attorney or a supported decision-making agreement. Okay, the rest of the document is going to cover resolving disagreements. And so this goes from pages 12 to 20. There may be times when you disagree with the actions that are taken by the school related to your child's special education and related services. Families are strongly encouraged to work with school personnel to resolve differences when they occur. Dispute resolution is a very broad topic, and there is a lot of relevant information. So we're only going to briefly touch on this during today's presentation, but some of the links on our additional resources slide contain more information about resolving disagreements. So the first method is state IEP facilitation. The disagreement must relate to an ARD committee meeting where mutual agreement was not reached on at least one of the required areas of the IEP, and the ARD committee agreed to recess and reconvene. Mediation services. The goal of mediation is to assist the parent and the school in reaching agreement. Special education complaint resolution. This is a written complaint that must describe the special education violation, facts on which the complaint is based, the parent's signature, and contact information. This complaint is given directly to TEA. And then the final option is the due process hearing program. So a parent can request a due process hearing from TEA on any matter relating to the identification, evaluation, or educational placement of their child, or the provision of FAPE to their child. So some additional resources on this topic that might be helpful to you. These are all found on the SPEDTex website. There is a document about what is the Individuals with Disabilities Education Act, or IDEA. There's also an overview of special education evaluations, a document about what is an IEP, more information on the special education complaints process, including an overview of that process, a document about resolving issues with your child's school, and then also a recorded statewide webinar that was conducted with TEA about dispute resolution in special education. SPEDTex is the Special Education Information Center for Texas, and we're a collaborative project between Region 10 Education Service Center and Texas Education Agency. We help parents to understand their rights and responsibilities under IDEA and facilitate collaboration when there are concerns between the parent and the school district. We also serve as a resource for educators. We offer support via phone, email, live chat for families and professionals, webinars, and resources. And our contact information is on the screen. You can also create a SPEDTex account. And with a SPEDTex account, families can receive customized reminders, volunteer to participate in focus groups and share feedback, locate resources that are tailored to your needs, and access trainings. And the SPEDTex account is completely free for parents and also for professionals. You can also follow us on social media. We are on both Facebook and Twitter or X, and that information is on the screen as well. I am going to turn it over to Jim to share some information about Partners Resource Network.
And Jim's going to find his mute button. So Partners Resource Network is funded by the Department of Education, and we serve as Texas's PTI. That's our Parent Training Information Center. In the IDA law, all states have at least one Parent Training Information Center, a PTI. And Texas is so large that we have 4. In Region 10 area, I'm the regional coordinator, and we are part of the PACT project of the PTI in Texas. Our information is here on the screen, and all of our services are free, and you can reach me directly through my phone number is 469-388-8662. So hopefully that'll be recorded. Or you can reach out to our 800 number and they'll direct the call to me. And we do one-on-one contacts, trainings, and information for parents. And again, all of our services are free.
Thank you so much. You can connect with us by signing up for the monthly SPEDTex newsletter. You can also sign up to be notified of upcoming Region 10 events, or you can sign up for the Partners Resource Network newsletter as well. Thank you so much for joining us today. My email is on the screen, so if you have any questions, please feel free to reach out. Thank you.
Can I put in a plug?